All rise. This court is now open. Please be seated.
Our next case is 23P234 Park Ridge Realty versus Destin Company. Mr. Johnson.
Good morning, Your Honors. May it please the Court, my name is Mark Johnson. I represent Park Ridge Realty, Inc., along with Attorney John Donnelly, who is with me as well. Once again, this Court is faced with a question as to the extent of General Laws, Chapter 185, Section 46, as to whether or not it protects landowners against claims of implied easement over their land. As the Court is well aware, the purpose of the land registration system is to bring finality to title. Section 46 states unambiguously that every plaintiff receiving a certificate of title in pursuance of a judgment of registration and every subsequent purchaser of registered land taking a certificate of title for value and in good faith shall hold the same free from all encumbrances except those noted on the certificate and any of the following encumbrances which may be existing and the ones that are listed are not applicable to this case. There is no question in this case that there is not a document creating an easement that gives Lot 7 rights to tie into a sewer line on Lot 8.
There is a document that creates an easement over Lot 7, isn't there?
There is a document, and if you're referring to the document in the earlier chain of title.
Easement and agreement.
I'm sorry?
The easement and agreement.
The easement and agreement cannot create an easement for Lot 7 over Lot 8 because Lot 7 and 8 were owned by the same party, and the party cannot create.
But the easement and agreement does create an easement, doesn't it?
It does not create a valid easement simply because you can't create an easement on land you own. And that's what that document attempts to do.
It creates an easement over the land that is Lot 7 in favor of the wart.
That is correct. But the easement, as it affects Lot 7's rights to Lot 8, it does not create a valid easement simply because you can't, one party cannot create a easement on its own land. That's why you would have certain conveyances would be subject to a reservation of easement, or there'd be documents of easement. There is no document that creates an easement in favor of Lot 7 over Lot 8. There are documents that create easements for other parties. In some ways, Your Honors, this case brings back memories of Patel versus the town of North Andover. And in some ways, as you do research over the years, you realize how old you are. As I tried Patel in the lower court, and that was 34 years ago, I realized when I was preparing for today's hearing. Patel is recorded land. In Patel, there was a plan showing a proposed future roadway over Mr. Patel's property. Similar to this case, there was language in approvals that may lead someone to believe that the easement would be used sometime in the future, but no easement was granted. This court held that the mere approval and recording of a subdivision plan indicating the location of a proposed roadway was insufficient to carry out the board's intent.
Okay, excuse me. So your certificate of title and deed, both your certificate of title and the deed, just like Destin's, they both refer to the E-plan, right?
There's no question it refers to the E-plan.
And the E-plan sheets 1 and 3 both show the sewer easement, right?
That is correct. So if my client had an obligation to investigate, you could investigate and still not find an easement. There is no grant of an easement. So the duty to investigate doesn't mean that you have to find a document that creates the easement. You can investigate, come away from the investigation, and say there is no document creating this easement.
There is a grant of an easement over Lot 7 and Lot 8 in favor of the, I can't remember what WART stands for now, but we'll just say WART.
Yes, but
that easement is over Lot 8 as well.
It is, but
that little short piece.
Got the little strip, but there was never.
So to say if you look in the registration system you won't find an easement is not correct, is
You will not find an easement, a valid easement, that benefits Lot 7 over Lot 8. That is not, and that's because you can't create an easement over your own land.
The agreement that accompanied the easement allowed the owner of lots 7 and 8 to tie into whatever the Wart might have constructed.
But at that time, 7 and 8 were owned by the same party, and therefore you can't create an easement over your own land. And that's why when I say there's not a valid easement, it's because that is not a valid easement. In the world of conveyancing, you may see certain documents within a chain of title. You may see on a registered land plan a notation that looks like it's a common driveway easement, but no common driveway easement has ever been granted. You can have things on a plan that doesn't mean they have to be granted. So the obligation when you're doing a title search is to go and look at the documents. Where is the document that creates this easement?
What's the relevance of the 1987 agreement, which released lots 7 and 8 from the so-called 1986 covenant?
From the planning board covenant, I don't think that's significant at all. I think you were substituting certain security that you couldn't sell lots for certain monetary security. I don't think it has anything to do relative to this particular easement. When you go
about the 1990 release of the 1991 release of the mortgage? Does
I don't
have
believe
anything
that.
to do with it?
I don't believe that's relevant to whether or not there is a valid easement. And again, we're talking about whether or not the easement was a valid easement. You investigate, you go through the records of the registry, you make a determination as to what documents support, what documents create an easement. And in this case, there are not documents which create an easement. There may be documents that could lead you to believe maybe one was anticipated, but anticipating doesn't mean that it's created. The covenant does not talk about specifically a sewer easement. The covenant does not talk about who it benefits. The covenant is a planning board covenant in the normal course of permitting, which you don't sell lots until certain work is done, or you can replace it with security. There's nothing in the covenant that obligates an easement.
So I'm thinking you're making arguments a little bit different from the one in your brief. I mean, in your brief, you sort of harped on the fact that we're turning certified land into recorded land, and there's no difference. But you're saying now, basically, that even if this were recorded land, we could search high and low through all the records, and we still wouldn't find an easement.
That is correct, Your Honor. And the irony here is that in the recorded land at Patel, this court found that absent a recorded easement, which in Patel they thought had to be done within 2 years under the permitting, and there's language in this covenant as well that something had to be done within 2 years. Absent a recorded easement, there wasn't any easement over the Patel property. I mean, the irony is that it appears in some ways that Patel had greater rights on recorded land than what Parkridge was given by the lower court in this particular case. Because again, Patel found I think one of the critical factors in Patel was that there was not a deed recorded or an easement deed recorded. And again, that's recorded land. That doesn't have the benefit of the statute. The statute has to mean something for recorded land. The idea is to not have uncertainty as to title. Not to say that somebody has to go back and infer different documents. And we're talking about an easement, an interior easement. We're not talking about land that may be abutting a road. Someone may own a portion of a road. I mean, we're talking here land that goes through somebody's property. The typical terms of an easement is something that a buyer would like to know. Typical terms will go to indemnification. Who has the obligation of repair? What if this hazardous material flows into it? I mean, there are a number of things, that are laid out within a typical easement agreement. You don't find any of that in the record here. So you may have an obligation to investigate, but again, it doesn't mean you have an obligation to turn up documents, certainly documents that are not an easement document.
But so you have no problem with the thought that your client was under an obligation to look at the E-plan, for example?
The E-plan is there.
Okay.
Your
client was on notice of it?
Whether or not he had personal knowledge of it or not, I can't answer that question.
The certificate of title gave sufficient notice to at least look at the E-plan.
Yeah, I'm not.
And you're saying, and then you see E-plan, look at that, it says sewer easement, but okay, now I'm on further notice. But then you look through all the documents in the registered case, and you don't find. You've explained there are some documents that we can disregard, and at the end of the day, there's no easement.
And at the end of the day, there is no document that creates a valid easement. And you make calls all the time when you're doing title searches and you're going through the record. I mean, that's why you're doing it.
Did that easement still exist, the short easement over Lot 8, did that still exist in favor of the land, at least formerly owned by the WART at the time of, say, at the time your client purchased the land? Did that easement still exist in favor of the ward?
I'm not sure, Your Honor. I don't want to answer the question incorrectly. I'm certainly happy to provide the court with
That's why I was asking about the 1991 release of the mortgage and the 87 agreement, which released Lot 7 and 8 from the 86 covenant. Do those have anything to do with whether the easement still existed?
No, it doesn't. A bank releasing a mortgage can't create an easement. I mean, it's a.
I'm not asking whether it was created. I'm asking whether the easement that we can see in the records still existed.
I don't know the answer to that. I'd have to look at the record, Your Honor. I don't want to give an incorrect answer on that. I'm happy to follow up with the court to answer that question. But there is an easement document.
So you haven't argued that it didn't still exist?
I'm sorry, Your Honor?
You haven't argued that it did not still exist?
I'm not arguing that. But what I am arguing is that there may be a release of a mortgage, but the release of the mortgage cannot create additional rights it cannot create an easement that doesn't exist. And the release of the covenant cannot create an easement that doesn't exist.
How did your client find out that there was a sewer line going through the corner of the property?
I think, and again, the record is not clear in this, and that's why summary judgment was not granted as relative to the other issue. I think my client learned when he had some title work done and learned that there was not an easement, that there was no formal document creating an easement.
But it's, right, but I mean, how does he know there's a sewer line there?
I'm sorry, Your Honor?
How does he know there's a sewer line there?
I don't think there's any question he knew there was a sewer line there, but I don't think he knew that anybody else had easement rights to use it. And again, again, the granting of an easement is granting of property rights. I mean, and you can have a license absent an easement. You can have some rights to do things, but it doesn't rise to the level of an easement. And
the sewage flows north through those lines? Is that correct? Which way does
which way does the sewer flow?
Right into the Merrimack River.
No, it can't go into the Merrimack. We know it can't. It's opposite the Merrimack. Merrimack has enough problems. So it's.
Does it flow from Lot 7 or south of Lot 7 to Lot 8, or which is what it appears? Or does it flow in the opposite direction?
It flows, we just pull out the right plan. It's flowing towards, I believe, Lot 10.
Okay, so does, Lot 8 doesn't use that easement, does it? Or doesn't use the sewer pipes in that easement area, does it?
Lot 8 may use the sewer pipes in that easement.
Lot 8, I'm sorry?
Lot 8 may.
May or does?
I believe Lot 8 does.
Is that in the record?
I'd have to check whether or not it's on the record or not. I mean, but again, I think I go back to what I believe this case is about, is whether or not there is an easement, not whether or not at some point in time.
The way I at least understand the case at this point is that there was an easement created in favor at least of Wart over that portion of Lot 8 at some point, and that would be learned by examining documents within the registration system. So then the question becomes, is there something implicit about the presence of that easement there that means it favors or can be used by Lot 7, even if that was never spelled out in the papers? And
I guess my answer to that, Your Honor, would be it needs to be a document that creates the easement for the benefit of 7 over 8. That 7 does not have the right to tie into 8 by way of an easement without that document. And a document needs to create the easement. And that's where we differ with the land court decision. again, there's a duty to investigate. I'm not saying there isn't, but it doesn't mean your duty to investigate has to reach the outcome that there is a valid easement when there isn't. And if Your Honor would like me to briefly follow up to the court with the court on the two questions asked today, I'm happy to do so.
No, thank you very much.
Thank you.
Mr. Caruso.
Morning, members of the panel. May it please the court. Peter Caruso II here. I have my father, Peter Caruso Sr., here observing with me. Your Honors, this is a classic case, we believe, that falls on the Jackson, Knott, Duddy, Hickey line of cases. And just to take up on the discussion about the Wart easement, it does exist. It did exist. It was not extinguished in any way, shape, or form, and it was between two separate parties. The owner of Wart had the easement agreement with the predecessor and title to the to our two clients here at this point in time. So there was an easement that was actually established that extends from Lot 7 through Lot 8. As to the usage by Lot 8, they have, as has our client, engaged in an easement with Cedars, a neighboring, very large neighboring landowner, to use that entire easement system, and that's in the records, Your Honor, right across, using as a reference the E-plan and the sewer easement, sheet 3 on the E-plan, in both easements, signed by my client and signed by Attorney Johnson's client. So
Where is that in the record?
Your Honor, I can point to it. Right, I'll give you the page in the index. It is, the two easements are on pages 363 to 369 of the record appendix and 372 to 379. So there is some acknowledgement of the fact that there is, in fact, an easement that is running through Lot 7 and Lot 8, Your Honors. And if I could speak to a moment on the intent, the Duddy cases and the Hickey cases all attempt to resolve an issue where there isn't a potentially specific grant, but what is the intent during the subdivision? And then Hickey further expands on that line, saying, what's the progression of the development? And Your Honors, if you look through the record, this started with a 40-acre parcel of land along the Merrimack River that was subdivided a number of times. And the first few subdivision plans didn't make any mention of easements. However, Plan 32116C, which is page 208 of the record appendix, does create two permanent easements for municipal sewer. Of course, we're right on the Merrimack River. There had to be some sort of sewer system aligned for all of the parcels. And then you continue on.
So is that created just by putting it on the plan, or are there also documents that back that up?
Your Honor, at the time that the plan was created, there were no documents that documented that particular easement. I would submit that the first documents that actually addressed specifically that, or first document that addressed that easement, is the easement agreement that Justice Sachs was referring to. That's the first time we have an actual statement of the easement. But if you're looking through the progression, there are other documents in here in Certificate of Title 56949, which if you examined, as the Jackson and Duddy courts suggest, if you examine the record, you would see that that certificate of title is rife with references that would give any reasonable purchaser knowledge of the fact that an easement was at least intended during the progression of the development.
So that was 56949?
56949, which is page 239 to 242 of the record appendix. And there you will find the reference, as is in the certificate of title, to the E-plan. You will find reference to document 229421, which is an agreement with the City of Haverhill referencing the E-plan regarding the sewer easements. You will, in fact, find document 26793, which is that easement and agreement that specifically shows the easement in question extending through what will become lots 7 and 8.
So how do you respond to Mr. Johnson's argument that you can't give an easement to yourself?
Well, I don't think he did. Respectfully, I'm not sure they did give an easement to themselves. I think it was an easement between an abutting recorded landowner, parcel A, Wart, and between the owners, the predecessors in title of both Lot 7 and Lot 8. I think there was a valid easement that was created that extended over what becomes Lot 7 and Lot 8. And I think that's possibly instructed the reason why in the partial release, the mortgage company made a specific reference to the fact that they were releasing any and all rights in that easement area, as well they should have. Also, and as I just mentioned, we can't ignore the sewer easements that were placed on by both of our clients at the end of this. If there had been a question whatsoever over the use of that easement, and those easements were put on a year or 2 years ago perhaps, forgive me if I don't have the date correct, but those easements specifically reference, as everyone has been reviewing and referencing these easements throughout the title, to that E plan. Now, is there a question?
Those date from, what, 2019, do I recall? Is that?
I'm sorry,
When do those date from? The agreements you're...
The new sewer easements?
Yeah.
They are dated from, I believe,
I see 2018 and 2019.
Correct.
But is there any, I see both parties here agreeing with Cedars, but I don't see an agreement between the two parties here.
You're correct, Your Honor. That's true. Yeah, and I'm not suggesting, Your Honor, that those two easements created any rights between the two parties. I'm just indicating that it's further evidence of the intent of the progression of the development here. Your Honor, there's some in the supplemental brief that was filed by the appellants as well. They attempt to add two other cases that they believe are distinguishing. The first is a sort of a Hickey 2, we call it. I believe it's Louiselle versus Hickey. In that particular case, the court had remarked that the Hickey parties were coming back for a second bite of the apple just to see how far they could push things. And I think it's illustrative of what our point is here. In the Hickey court, they did in fact find that there was an easement that benefited a landowner that wasn't on their certificate of title. In the Hickey 2 case, they were attempting to expand on the rights of that easement. They weren't trying to establish the easement, they were trying to expand on the rights, indicating that they had rights for fowling and fishing, et cetera, beyond sort of an access easement. So I think that that's distinguishable. And I think all of these cases are very fact-dependent here. Another point I'd like to make is, yes, while I'm aware that there is supposed to be a degree of finality that the enabling statute for land registration provides, the cases consistently down the line have said, well, we may be able to grant relief in very specific instances if that relief doesn't impede the land registration system. And Your Honors, I don't think this would impede the land registration system at all. This is a sewer easement that was very clearly identified, and it just wasn't easement on the plan, it was sewer easement. And there are documents that support the fact that we believe the easement was actually created by that easement agreement, but there are documents that support the intent of that easement running throughout the record that would put any reasonable person on notice. And as the land court indicated, we do think this is similar to Duddy, and it's similar in that, A, there was a plan that was actually specifically referencing the easement. The easement centered on crossing over the appellant's land. They focused on intent and progression. We're relying on that. This is the sewer easement, Your Honors, that grants access to the main municipal sewer easement for Lot 7. There is no other avenue of connection. Hence why Cedars approached our clients and said, we're down the line here. Is there a possible way we could have a connection? There's no other way to get there. There are wetlands surrounding certain areas here. This is the way it was supposed to go.
With reference to Plan E, where is Cedars property?
If you look at, I'll pull it up, Your Honor. I believe if you look at...
I'm looking at the 2018 and 2019 agreements, and it refers to a Plan F, but I haven't seen that.
Yeah, I haven't seen that either, Your Honor. The Plan E, if you look on I believe it's the first page, and I'm trying to call it up for you. They're on the lower, and without giving you direction, they are lower if you're looking at the plan, lower left side there. So they're down below on the sort of
The
southerly.
neighborhood of where Wart was, if not the same land.
Yes, Your Honor, correct. So that's where they were attempting to connect. So at the end, Your Honor, we do believe, A, that there is an agreement that's out there that specifies as an easement, and B, Your Honor, we believe this does fall in line with the findings of the Jackson, Duddy, Hickey progeny.
So it's, in your view, it's necessarily implicit in the grant of the easement over to Wart, over lots 7 and 8, that lot 7 would have the right to tie in?
I believe it specifically says that in the easement
No,
agreement.
That's an agreement. That's
Agreed.
not the easement itself.
Understood. So yes, Your Honor.
And that easement over lot 8 is still in effect. It was not affected by the release of the mortgage or the 87 agreement, which released lots 7 and 8 from the 86 covenant.
No, Your Honor, it's still in effect, Your Honor.
All right, because all those things were talked about by the land court, and I wasn't quite sure what the relevance of them was.
Understood, Your Honor. I think the relevance was going to the intent as to that even third parties were looking at the plans and looking at the documents and realizing there were rights that they believed existed in the easement and they had to release them as a matter of course.
So a lot of this, the issue of, how the importance of the, the registered land system is here. So we're ultimately, though, we're depending on a judge and somebody in the land court surveyor's office or something, right, to look at to look at the registration case and figure out what's going on, and they don't mention a sewer easement here. Wouldn't that be kind of important?
Mention a sewer easement in
the certificate of title. I mean, the only right, it doesn't have any, it doesn't reference any encumbrances, does it?
I'd submit it's important. Is every important easement and restriction of record on our certificate of title? I'd submit they're not, with the best of intentions. I submit they're not, hence why we have the Duddy case as the exceptions to the rule to try to solve for that issue, Your Honor.
It ultimately comes down to some fallible people who are neither of the parties.
Potentially, Your Honor, yes, correct. But I think there's a solve for that, and I think the solve, again, is the intent and the progression. We don't want to, we're not trying to use, or we as conveyancers should not be trying to use the land registration system as a weapon. And I'm not saying that's what's happening here, but it's not supposed to be a weapon. It's supposed to give some sort of finality. But this is simply establishing a sewer easement over a very small portion of Lot A that is essential to the entire development. And it's essential to not just Lot 7, but to other surrounding lots and to the success of the subdivision.
Try one more time. Why is it necessarily implicit in the grant of the easement to Wart that Lot 7 be able to tie into it?
That Lot 7,
I mean,
Your
I
Honor,
recognize
think,
that it's an existing sewer easement, and it might make perfect sense, might be most economical for Lot 7 to tie into it in order to get sewer service, but in theory, Lot 7, once there's separate ownership between Lot 7 and 8, could purchase another easement over Lot 8 to tie into that municipal sewer line.
They could, Your Honor, but there's specific language in that easement and agreement that does indicate that either party, whether it's Wart or whether it's the owner of Lots 7 and 8, can use and install sewer lines on that sewer easement.
But at that time, Lots 7 and 8 were in common ownership, so that wouldn't have been done unless the party that owned Lot 8 was willing to have that sewer easement take that additional burden of the portion of its property that was on Lot 7. Once there's separate ownership, it doesn't seem quite so necessarily implicit.
Perhaps, Your Honor, but I think it was the agreement between the parties at the time, and Wart certainly had the right to do that at that point in time, and if Wart had elected the right to connect through that sewer easement, then certainly the owner of Lot 8 and 7 and 8 could have easily installed infrastructure on that sewer easement. It was specific in that easement and agreement. I think it goes to the intent, Your Honor. I wish it were more clear, but I think all of these documents go to the intent in the progression of the development, which is the exception that we're trying to fit into.
Thank you.
Thank you. Thank you.
The last case is 23P 629, PJ Keating Company versus the Town of Acushnet Board of Health. Mr. Murray.
Good morning. May it please the court. Jonathan Murray on behalf of the Town of Acushnet Board of Health. Your Honors, this is a public health nuisance case. The nuisance at issue is odor emanating from the appellee's hot mix asphalt plant.
You say public health nuisance. Does it have to be a public nuisance for us to rule in your favor?
That's what the case is about. There is no private nuisance action. The case law makes a distinguishment between a private nuisance and a public nuisance. What the Board of Health received were complaints from the abutting residential neighborhood that the odor emanating from this hot mix asphalt plant was coming onto their property.
We know what the board heard, but what did the board rely on in affirming the cease and desist order? I see the cease and desist order relied on the DEP reg about contributing to condition of air pollution. Then the Board of Health decision seemed to rely on Section 122 and maybe Section 123 or 4. What is the basis of the order that is before us?
So the initial cease and desist order referenced both the DEP regulations and the Board of Health's inherent authority under Chapter 111, Sections 122 to 125 to abate public nuisances. The board's decision, however, addressed only the Chapter 111 element of that. As to your question on what they heard,
7.09 is out of the case?
They did not include it in their decision, no. As to your question on what they heard from the Board of Health has 2 inspectors or agents. They heard from both of them. They heard sworn testimony from 7 neighbors who live in the abutting residential neighborhood. They heard from employees of PJ Keating, and they received and considered both expert opinions from PJ Keating's experts, scientists, and the board retained its own peer reviewer. So that's the scope of the evidence it heard. And after the conclusion of the hearing, it determined that the odor from the hot mix asphalt plant, which emanated onto this residential neighborhood and the properties of those people who testified under oath at the Board of Health hearing, was a public nuisance.
Did they say a public nuisance, and does it have to be a public nuisance under Sections 122 and 123, is it, or 124?
It's all of them, 122, 23, and 24, and 25. It is a public nuisance. That is what the board found. They did not find it was a private nuisance. They were responding to complaints.
Well, the board didn't say public nuisance. Are all nuisances divisible into public nuisances or private nuisances?
It depends on the mechanism by which they're trying to be enforced, I would say. I would say under this case where they specifically invoke Chapter 111 and those sections 122 to 125, that we're considering a public nuisance. We're not considering a private nuisance. We're not considering a claim between these private individuals and this private corporation.
Well, the reason I ask is that Section 123 says the board can order the owner or occupant of any private premises to remove any nuisance, source of filth, or cause of sickness found thereon.
Yes.
So, I didn't see where the board's decision, and correct me if I'm wrong, referred specifically to public nuisance. So, do we need to worry about the precise definition of public nuisance here?
I would say that the board referenced Chapter 111 and that they did order that the odor stop until the nuisance is abated. So I think that it's implied based off of the proceedings before the local board and the reference to Chapter 111 that we're talking about a public nuisance. I would say
Just to zero in, does the board have to find that the odor was injurious to public health? That's in Section 122.
yes,
Okay.
and they did. And that was set forth at the beginning of the hearing when the board, if you set the ground rules for what they were going to hear, is they were trying to determine whether this odor from the hot mix asphalt plant was injurious to public health. And I cite many of the testimonies at pages 21 and 22 of my brief, but just to summarize them very briefly, someone testified that my nose gets irritated, my throat gets sore. Someone testified that they get dizzy, eyes are watering, sinuses are irritated, eyes burn, water, throats hurt, burning, dizziness, nausea. And based off of all of this testimony, these 7 people who lived near the property, who specifically identified the hot mix asphalt plant odor as causing them injury, the board found it to be a public nuisance under Chapter 111.
Does there need to be, it seems as if the expert evidence was that there is no significant risk to public health. And my question is, does the risk need to be significant in order to be a public nuisance?
So I would answer your question in 2 parts. The first part is, I think there was a dispute as to the expert evidence between P.J. Keating's expert and the board's peer reviewer, Dr. Martin.
Well, he said, I'm not claiming that it's a significant risk, but you can't say there's no risk.
Yes.
So if there's some risk, but it's not a significant risk, can it still be a public nuisance?
Yes. But I would say...
What's the authority for that?
I just want to make sure I'm answering the question.
What authority says that an odor that needn't cause a significant health risk in order to be a public nuisance?
It's Chapter 111, Sections 122 to 125, which says, in the opinion of the Board of Health, something, a source of filth or a cause of disease or something injurious to the public health. And that's what they found in this case, that the odor specifically was injurious to the public health. And that's why the board would submit that the trial court's decision was an error. The standard, well, there's 2 arguments. The first is jurisdictional, and I can go into that, but we're talking about the injurious to public health. It's the arbitrary and capricious standard. The trial judge does not weigh evidence, does not find fact, does not exercise discretion or substitute its judgment for that of the administrative body. And that's what we had in this case. I would submit that the trial judge weighed evidence on her own, found facts, weighed whether or not the testimony of these 7 affected individuals who testified under oath that they were experiencing negative health effects was credible or not.
The judge says that the board didn't find a public health nuisance or an injury to the public health, and there wasn't any credible evidence that there was injurious to the public health.
Well, I think that's our argument, and that's our error, is that her finding that there was no credible evidence was her substituting her judgment for that of the board. The board heard this evidence, heard this testimony.
But did the board determine that there was an injury to the public health?
Yes. Let me grab the decision here. In the heat of the moment, it's sometimes hard to remember where my document is. I apologize.
I see that on page 542, Board of Health decision, it's a nuisance, source of filth, and cause of sickness.
Thank you.
But I don't see, I mean, specifically anything about public health.
Well, it's citing in the first paragraph, chapters 111, sections 122 to 125. Your Honor, I think something to consider is when you have a volunteer board, you don't always get, a volunteer board made up of lay members of the public. You don't always get perfect legal writing, but what you do get...
The cases saying so, aren't there?
I apologize?
There are cases saying so.
Saying what, Your Honor?
Saying that we don't expect
Yes.
perfect legal writing from members of boards of health.
Absolutely, Your Honor. And to to finish that point.
That doesn't mean that the Board of Health's opinion standing alone and without judicial review can be enough to order a plant like PJ Keating to shut down, does it?
No, Your Honor, but I think in this case where we heard from, we put people under oath, we heard from experts, we heard from the town's inspectors, we reviewed documents, including complaint logs, a reasonable person would find that the board was, that there was sufficient evidence to support the board's finding that under Chapter 111, a nuisance did exist, and that the odor specifically was injurious to the public health.
Is there evidence about whether there were complaints before PJ Keating moved the plant from, as I understand it, the rear of the property to the front of the property?
My understanding, and I'll just preface by, I don't know the exact answer. My understanding and my recollection is that there has been an ongoing dispute between this residential neighborhood and the town in general and PJ Keating.
Well, I saw some references in the testimony of the residents to, this wasn't a problem before PJ Keating moved its plant.
Yes.
I guess what I want to know is there something in the record suggesting that it was a problem before PJ Keating moved its plant?
Not that I'm aware. If you imagine, there's a site photograph in here, but if you imagine that the site is a rectangle, the residential properties along the northern side of the rectangle, that's where the hot mix asphalt plant was moved to. It used to be on the other side of the property where it was abutting vegetative vacant land. So when it was shut down in 2020, and I believe there's testimony in there from both employees and the inspectors that the plant started back up again in September, October of 2021. That's when there was a renewed or this outcry from these neighbors who were experiencing the negative effects of the use. They, like I quoted from page 21 of my brief, they were experiencing these sore eyes and nausea and dizziness. Some folks are afraid to take their grandchildren outside because of the complaints. When this plant started operating again near the residential neighborhood, that's when citizens made complaints. There was investigations.
So PJ Keating's expert evidence says, in essence, that the odors and emissions don't pose significant risks to public health. Is there an actual conflict between that evidence and the board's decision, which seems to credit the residents that they're suffering burning nose and sore throat and watering eyes?
I would suggest, and I would point you to the board's peer reviewer, Dr. Martin, his letters reviewing those studies. One called into issue the generalness of these studies, that in general, these plants may not cause harm, but it didn't look at the particular, it didn't look at this particular site, and what the board relied upon were the people day-to-day experiencing the effects. So while I certainly recognize that there were peer experts and that they have scientific knowledge that these types of structures or plants generally have a specific category of effects, be it negative or not, that's a generalization. It's not the particular site, it's not the particular weather conditions, it's not the particular injurious public health effect that this particular plant was causing on the neighbors.
So, in other words, the board could have fully credited what the experts actually said, but still ruled the way it did? Could have credited what PJ Keating's experts said?
Yeah, certainly. You could imagine a scenario that the board say, we credit your expert testimony that these types of hot mix asphalt plants generally do not have, and I think this is in the vein of what they decided, generally do not have these types of negative impacts. But when you then have specific evidence as to the specific site, not generally as to what hot mix asphalt plants cause in the community, but this particular one and the odor from this particular one in relation to the surrounding properties and the...
So is there anything in the green toxicology report, I guess it is, that says that hot mix asphalt plants can't cause nose and sinus irritation, sore throat, and burning eyes? What I'm getting is there a direct conflict between PJ Keating's expert and the testimony of the residents that the board appeared to rely on?
I would submit no. I would submit that the expert testimony submitted by P.J. Keating was general in nature, that generally these are the types of effects that hot mix asphalt plants have. However, in the specific case, and what the board credited as credible testimony, is that we credit the folks who are injured, who are suffering from these effects, and we give their testimony the credit.
Can I ask real quick, Mr. Legere starts his brief with saying that the board, that Hannon issued the order a mere 3 weeks after the Superior Court had enjoined the appellants from enforcing an August 2020 season. So it sounds like there's a history here. Do you care to comment on the history? Is there?
There is, I'll concede, there's quite a history between P.J. Keating and the town, multiple enforcement actions, multiple different statutory schemes, but this one in particular was a public health, Board of Health action.
What was the last one that got enjoined?
A few different things. There was actions under the state fire regulations for explosions and blasting. There were an action under the town's general bylaw as it pertains to soil removal. There was an action under, there's quite a list.
Okay,
but this is the instance of public health.
Okay, thank you.
Thank you, Your Honor.
Mr. Legere.
Sorry.
Good afternoon, Your Honors. May it please the Court, Luke Legere on behalf of Appellee P.J. Keating Company. Just to pick up on a couple of points that Your Honors were correctly homing in on with Mr. Murray's arguments, I would encourage the Court to look at the transcript of the Board's proceedings, because the notice of decision does not at all track what the Board actually ruled and found during the course of its proceedings. The Board of Health did not once mention in its deliberations the word nuisance. Not once. They didn't, public or private. But where we were talking about public nuisance, there was no mention of public nuisance.
But they do in their decision, so why does it matter whether it was mentioned during the hearing?
Well, because, Your Honor, it's up to the Board to make these findings and determinations that would then be reflected in the notice of decision. The notice of decision does not actually track what the Board found during the course of and at the conclusion of its public hearing on this. There was no mention of any sort of a nuisance on.
So they had to say the word nuisance at the hearing?
I believe, Your Honor, some.
Didn't town council give the board a definition of nuisance at the outset of the hearing?
Absolutely, Your Honor. And I think that goes back to the point that my brother made about a board not being expected to craft a perfect decision. We certainly understand that. This also wasn't your typical municipal board proceeding. Town council was present at each night of hearing. There was a stenographer. Witnesses were sworn in and testified under oath. Evidence was marked in as exhibits. This was a full-blown adjudicatory proceeding.
Is there any reason the board couldn't credit the residents' testimony?
The board could credit the testimony of the residents, Your Honor, certainly.
Okay. And is that testimony in direct conflict with the expert testimony? Could the board credit both?
So I think they could, Your Honor, but going back to Your Honor's comment a moment ago, where town council started the hearing by giving the Board of Health a standard that in order to find a nuisance, the board needed to determine on the evidence before it that the odors emanating from Keating's facility were injurious to public health. The board needed to track back to that, and that just never happened. And although some of the residents...
Is the point that it's not sufficiently injurious to these residents, or that there are not enough residents to make it a public health issue?
I would say more the latter, Your Honor. So that was the point I was just...
So how many residents is enough?
Well, Your Honor, we had a member of the Board of Health estimate that there are 150 homes in the neighborhood where the complaining residents live. The board heard from 5 residents, Your Honor, complaining about odors emanating from Keating's facility. 2 other residents complained about odors from trucks traveling along South Main Street.
Those were P.J. Keating trucks, weren't they?
We don't know that, Your Honor.
Well, it's trucks carrying hot mix asphalt. Isn't it a reasonable inference?
Certainly, if that's true, Your Honor, but I would submit I don't believe there was evidence from these residents that every single truck they were complaining about actually did contain hot mix asphalt. The point is
testimony about asphalt trucks coming by, so.
fair enough, Your Honor. The point is to simply say, even if we credit all 7, that's 7 out of approximately 150 homes. And when we're talking about a public nuisance, there does have to be some weighing of how many individuals are impacted and harmed and complaining of these types of effects. And Judge Sullivan at the trial court level properly recognized that in a case also called Sullivan, somewhat ironically, and others that we cited in our briefs and that the court relied on below, for a public nuisance to exist, there needs to be some significant portion of the population that's going to be affected. It can't just be a few folks who are, for whatever reason, especially susceptible or sensitive.
Is there any evidence that they're abnormally sensitive?
I think there is, Your Honor, in that when only 5, or excuse me, when we'll say 7 residents show up out of 150 to this hearing to testify, I think that's evidence. I would also add, Your Honor.
Why is that evidence that they're abnormally sensitive? Maybe other residents didn't know about the hearing or weren't bothered enough that they were going to come out. They figured, okay, the board will hear from my neighbor. I will just be repeating my neighbor's testimony. There's no point in me going.
Well, Your Honor, I would add that the evidence submitted to the Board of Health of complaints that had been filed leading up to the hearing reflected that of the complaints received, fully 1/3 came from 2 to 3 people. So again, it's a really vocal minority of folks who seem to be especially sensitive to odor who are complaining and driving this Board of Health decision, despite the fact that the vast majority of people haven't lodged a complaint in any way. And I should add, Your Honors, in what, in my experience, is an incredibly unique, if not unprecedented situation, the town of Acushnet established on its town website a portal for residents to go and file complaints solely against PJ Keating Company. So it's not a situation where the residents don't know how they might be able to lodge a complaint. They know exactly how to do that. It couldn't be easier for them, and yet it's still a really small minority of residents who are actually lodging complaints.
So Section 122 says the Board of Health shall examine into all nuisances which may, in its opinion, be injurious to the public health. And 123 says the board shall order the owner or occupant of any private premises to remove any nuisance. Why does it have to be a public nuisance in the sense of affecting some significant portion of the public?
Well, that's what the board was alleging, Your Honor. I don't believe the Board of Health would be able to prosecute private nuisance situations.
Well, this is my question. Why do we have to divide when the statutes say all nuisances or any nuisances? Why do we have to say this either has to be a public or else it's beyond the board's purview?
Well, I would say, Your Honor,
The board
that
can't do anything if some residents are complaining because there are not enough residents complaining?
well, the board can certainly investigate as it did here, Your Honor. I would argue that private individuals have a private right of action to sue for private nuisance. That's not something the board could take on in our view. A board in investigating a nuisance, in our opinion and from our perspective, is necessarily investigating a public nuisance.
But why doesn't any in Section 123 mean any nuisance?
I take that to mean, Your Honor, any nuisance in terms of whatever form the nuisance might take, not any nuisance in the sense of private versus public.
But it doesn't say any public nuisance. And likewise, 122 says all nuisances.
Understood, Your Honor. Again, I would just go back to my prior answer. I don't believe a Board of Health would be able to prosecute on behalf of individuals a private nuisance, have a right of action to bring private nuisance claims. I think that would fall to the individuals themselves. The Board of Health's purview would be for public nuisance type claims like the one we're dealing with here.
Is the board asking PJK to do the impossible to stop odors coming from the asphalt plant? Essentially,
Your Honor. This is the type of operation that is going to have some odor associated with it. Keating has, since the time of this cease and desist, at great expense, put in a lot of additional safeguards to try to further mitigate odor. But No one is saying there's no odor associated with a hot mix asphalt plant. What we are saying is that Keating is operating pursuant to a permit from Mass DEP for exactly this type of facility. Its property sits in an industrially zoned district.
Does the permit have some odor restrictions on it, like you can operate as long as you don't create odors measured however odors are measured, or as long as you don't bother more than 5% of the residents? In other words, does that permit provide some protection against odors?
It certainly does require for use of what's called best available control technologies to mitigate impacts from odor. It doesn't have...
That's like a design standard. It's not a performance standard. Is that accurate?
That's fair, Your Honor, but so it doesn't necessarily have the specific types of performance standards Your Honor was just mentioning, but certainly baked right in there is the idea that Keating's facility must comply with applicable laws and regulations like DEP's 310 CMR 7.09. I would also just like to stress for the court that the cease and desist order that was issued explicitly states that it was issued for violation of that statutory regulations, 310 CMR 7.091. If you look back through the record at at Keating's notice of appeal, at all the notice of hearing, agendas, the first night of hearing, the chair read into the record the language from that provision of the regulations. Everything ties back to 310 CMR 7.
Well, but the board's final decision didn't rely on that for whatever reason. And Mr. Murray said it's not included in the final decision, which I took to mean that we're not reviewing for whether this order can be supported based on 7.09.
This goes back to the point I was making earlier, Your Honor, really encouraging the court to look at the transcript and what the board actually did and voted.
Read the transcript.
No, I've cited for you exactly where in the transcript you will find the board voting to uphold the cease and desist order. And the notice of decision, which my brother referenced, explicitly says the board voted to uphold the cease and desist order. And town council, after the hearing concluded, in explaining to residents what this meant, said the board just voted to uphold the cease and desist order. So I query how the board could have extracted from its final decision the standards and requirements of 310 CMR 7.09, where that was the fundamental basis of the cease and desist order. The cease and desist order is 2 pages long.
So if we're looking at 7.09, what's the definition of contributing to a condition of air pollution that governs the board?
So what you have to do is take that in conjunction with 122, because that provision of the regs doesn't exactly give you that. It essentially just says, thou shalt not create.
Well, but why do you have to look at 122? The DEP regs expressly confer jurisdiction or authority on boards of health to enforce 7.09.
They do. They do, Your Honor. And
so what does 7.09 mean?
So 7.09 essentially says that as part of DEP's air pollution regulations, owners and operators of a private facility like Keating's cannot cause odor or dust nuisances, essentially. And then I believe you do have to read that in conjunction with 122 to understand how a Board of Health is to determine if nuisance conditions exist. And that goes back to the definition given by town council at the outset of the hearing, that the board needed to find odors to be injurious to the public health. And again, Your Honor, hearing from a handful of residents that they suffer fleeting symptoms under certain weather conditions where you have 3 expert witnesses all saying this is not injurious to the public health. That does not rise to the level of nuisance.
Did they say this is not injurious to the public health, or this does not pose a significant risk to the public health?
Well, certainly the latter, Your Honor, and I believe the town's own expert consultant stated in no uncertain terms, I'm not saying this is injurious to the public health.
I thought he said in no uncertain terms, I'm not saying this poses a significant risk to the public health. But he didn't say no risk, did he?
Well, either way, Your Honor, I believe that would be the standard that the board would need to apply, again, looking at the public as a whole, not simply a handful of residents who have lodged complaints.
Assuming we're looking just at 7.09 and the DEP authority to local boards of health to enforce 7.09, which I think comes from 142B.
Yeah, if I,
What does contributing to a condition of air pollution mean? Do you know of any statutory or regulatory or case law definition of that phrase?
I don't, Your Honor. I believe in the context of a public nuisance proceeding, it would be, again, the definition in Section 122 of injurious to the public health. I think that's why those two fit together. It's the particular type of proceeding we were in here looking at a public nuisance condition or an alleged public nuisance condition.
I'm a little confused by the reference to 142B that deals with the Metropolitan Air Pollution Control District. Is Acushnet part of the Metropolitan Air Pollution Control District?
So, Your Honor, the legislature established that district, I think, or commissioner, it was called. And if you read the language of that statute, it explicitly allows for DEP to include additional municipalities in there. So even though it's not specifically listed there.
Has Acushnet been included?
DEP. So yes, I believe, Your Honor, that through 310 CMR 7.52, DEP has extended that really to all municipal boards of health and their agents. So it's 7.52 that under the authority granted to DEP by the legislature in 142B then grants that further authority to boards of health and their agents to enforce 7.09.
So 142B at the, well, I don't know, maybe the end of the 5th paragraph, a very long one, says the Superior Court on petition of the department or any person authorized by the department shall have jurisdiction to enforce any such order and to restrain violations of any rules or regs adopted pursuant to this section. So does the reference to or any person authorized by the department mean a Board of Health authorized by 7.52?
I think it would, Your Honor, and the specific language I was referencing a moment ago actually appears in the very first paragraph of Section 142B, which says, sort of right down towards the end, that essentially, and I don't have the language right in front of me, I was trying to find it, but that essentially DEP can extend this authority to other municipalities. Again, 7.52 extends it to all boards of health and agents, and then if you look at 7.09, that explicitly incorporates 7.52. So that's how we get back to where we are, and again, are bringing this claim under Chapter 30A, which 142B explicitly allows for.
Thank you. Thank you both.
Thank you, Your
That'll
Honors.
conclude today's proceedings. I'd like to thank my colleagues, our court officers, our clerk's office, our law clerks, and our excellent timekeeper. And with that,